Hello, Tariq Samar, Tariq Ade here.
Already Judge Torshio Feaster, Assistant Public Defender on behalf of Mr. Day.
He's there. Can you turn on your camera, sir?
I don't have any contract with a public defender's office.
You what?
I don't have any contract with the public defender's office to represent me.
You don't have a contract with them?
Correct.
Yes, Judge. I reached out to Mr. Day to try to help pre-try this case.
Is this going to be a Bellinger's thing?
I think so, Judge.
Okay, go for it.
My understanding is that he had another counsel that he's going to have, I believe, on his file.
The courtroom springs to life with an immediate jolt. Confusion over who represents the defendant. An attorney appears and disclaims representation, while the defendant insists he'll defend himself. That friction, counsel or none, sets the tone. The judge tests procedure and patience, forcing everyone to clarify roles. This opening beat colors everything that follows and signals a bumpy, authority-driven hearing ahead.
And I wish him good luck if that's the case, but I don't see another attorney here, so I don't know what's going on, Your Honor.
No,
Mr. Day?
I'm defending myself. I told him that I would notify the court that I relieved him of any implied obligations to this case.
So you're going to represent yourself?
I'm defending myself, correct.
Okay, then you need to be here. Now.
Well, as I told the court, I requested a Zoom hearing because I have COVID. So there's no way I can.
In a vehicle with a hat on, no mask. Oh.
I am inside my vehicle right now.
What'd you say?
I said yes, because I'm inside my vehicle right now. I work outside. I'm away from the general public.
Did you go to the hospital regarding the COVID diagnosis?
Excuse me?
Have you been to the doctor regarding the COVID diagnosis?
It's against my religion.
Okay, so here's what you're going to do. Then I'm going to say, okay, you've got COVID. I want you here. When's our last block? 3 o'clock today. Wear a mask if you're going to represent yourself.
The defendant doubles down. He claims self-representation and cites COVID and religious reasons while joining remotely from a vehicle. The judge insists on presence and a mask if he plans to proceed, drawing a hard line between personal circumstance and court protocol. This clash exposes a tension between individual claims and institutional rules and foreshadows repeated conflicts about compliance and respect for courtroom procedure.
I can't make that. Is there a later date?
Oh, yeah, you can. 3 o'clock.
3:30, I can make that.
I'll be here at 3 o'clock.
Well, I'll be there at 3:30, and if there's any issue, then
okay, and at 3 o'clock, I may issue a bench warrant. Be here at 3 o'clock. I'll pass this matter. Thank you.
There's no bench warrant to be issued because this court didn't have.
Okay, I'll determine that at 3 o'clock.
The court
See
didn't
you at
have.
3 o'clock. Thank you.
This court does not have jurisdiction.
You're welcome, Mr. Feaster. Cut his line. Why don't we do this? Give me about 3 minutes. I'm going to take a recess, then I'm going to come back because everything's going downhill, and it's those two guys' fault. What's your name?
I'm Tariq Samar Tariq Ade, the executive of the Tariq Samar Tariq Ade Living Trust.
A ticking clock scene. The judge warns of a bench warrant if the defendant doesn't appear at 3 o'clock. What begins as scheduling becomes high stakes, with the defendant negotiating times and the judge asserting authority. The imminent threat of a warrant converts a minor dispute into urgent drama. Viewers feel the escalation and must watch tension, as a clear deadline forces action and tests the defendant's resolve.
Glad owner, Tariq Wilson Estate.
Sir, you indicated that you wish to represent yourself on this matter?
Yes.
All right. You understand at your arraignment you were given the charges that were have been filed against you?
I was given a charge. So if there were any additional, I was not given those charges. The only charge I got was a fleeing and eluding,
Fleeing and eluding third degree.
third degree, correct. And if anything else was tallied onto that, then I was not told.
Okay. I have one charge.
Okay.
That is a felony punishable by up to 5 years incarceration and $1,000 fine plus court costs. The Secretary of State would be required upon your conviction to suspend your license for a period of 1 year. You understand that, sir?
I do, but I have some questions.
Well, as soon as I get through this, you have indicated that you wish to represent yourself. I have to advise you that there are some dangers in you representing yourself. You understand that, sir?
I do comprehend.
And you understand that if you proceed to represent yourself, that the court is not going to assist you to understand the procedures or anything regarding the court proceeding, that you will be responsible for that, and I will be holding you to the same standard that I would be holding the attorneys in the room in terms of even ruling on evidence or anything along those lines in regard to the procedure and the process. You understand that, sir?
Correct. I comprehend.
All right. You also, so I will ask you again, do you still continue to wish to represent yourself in this matter?
Yes, I will be defending myself.
You understand also, sir, that should you change your mind and could not afford to hire an attorney and
This clip hits the legal reality. The defendant formally confirms self-representation while the judge reads grave felony charges, fleeing and eluding, jail time, fines, and a possible license suspension. The stark recitation of penalties reframes the defendant's confidence. The audience now understands the consequences behind the rhetoric. It's a necessary, sobering moment where the stakes become unmistakable.
be represented by an attorney, the court would consider making sure that you are afforded counsel. You understand that?
I comprehend.
How do you wish to proceed on this matter, sir?
First, I want to like an oral motion for dismissal based on the fact of the lack of probable cause and also the lack of personal and subject matter jurisdiction based on the fact that this is a trust matter from the name to the private conveyance that was stolen by the third party Wall Street Towing and impounded on the colorful law actions of Officer Trowbridge of the Washtenaw County Sheriff's Department. Also, I have not been able to, as of Constitution Amendment 6, being able to face my accuser. With the state of Michigan being a fictitious entity and there's no injured party, there's no crime that has been committed. And again, to the probable cause of the initial stop and the arrest, cannot be proven. There was no probable cause for the arrest or stop. There was no warrant on hand for the arresting officer to conduct an arrest. And even more so, again, as I stated, this is trust property, so this court doesn't have jurisdiction to adjudicate over the foreign trust.
Yeah. Finished?
Oh, no, actually, I was also moving to...
The judge warns about the hazards of representing oneself. Rules, evidence, and procedure will not be waived. The defendant responds with an oral motion to dismiss based on jurisdictional and trust-based claims. This is a tense, teachable moment where courtroom authority collides with unconventional theory. The judge sets boundaries and signals that procedural knowledge matters as much as passion.
Place you and the clerk as fiduciaries over the trust, and I'll be able to supply you all with the adequate assurance, certificate of security to settle and offset charges.
Well, you will be doing nothing to me and nothing to my clerk. So whatever that motion was, that's denied. As to your other motion regarding all of that, quite frankly, it doesn't make any sense. We haven't even had the probable cause hearing. There will be a determination at the next stage as to whether or not there's probable cause regarding the charges.
I was told this was a probable cause hearing.
This is a probable cause hearing.
So I don't understand what you're saying.
I know you don't understand.
They're not having a probable cause.
Pardon?
You said that no probable cause was had, but then you said that this is a probable cause hearing.
You have not had your preliminary examination. at which there will be a determination as to whether or not there's probable cause to believe that the crime has been committed and you committed it. That is the next stage. That has not happened. So to the extent that your motion is even valid, which I do not believe that it is, and certainly you may raise it at a later date, but to the extent that it's valid, at least at this point, your motion is premature, and therefore your motion is denied. Anything else?
Well, lastly, I want to also put on the record.
The defendant raises bold trust and fiduciary arguments, even asking the judge and clerk to act as trustees, a dramatic legal gambit. The judge promptly denies the motion, calling it inappropriate at this stage. The exchange highlights a gulf between creative, non-standard legal strategies and a courtroom's need for clear, applicable law. It's an illuminating clash of theory versus judicial pragmatism.
I wasn't able to provide all my exhibits based on, as I told you, I was.
You weren't able to do what?
Provide my exhibits
To whom?
to the court to help for my defense, the evidences.
You haven't had a hearing yet.
I comprehend it. I'm just saying that I usually have my documents precede me before any hearings take place, and I wasn't able to because I was under the weather. That was my point. So they will be here, if not by the end of the day in the drop-off box, and you'll have them tomorrow. But you all will be served with the proper documents, and the taxes as well will be filed on the case.
Okay. Anything else?
No, not this time.
All right. So how would you like to proceed next on this?
I'm entering a plea of demurrer.
Okay, you've already done that.
I've already entered a plea of demurrer. I'm not sure when that took place other than right now.
That took place on the arraignment on the complaint, sir.
I never pleaded demurrer.
You stood mute, you stood demure. You don't even know what that means. You're just using words and have no concept as to what they mean.
Demurrer and mute are two separate things, but that's neither here nor there.
No, they're not. You have no legal degree. They are not. They are not.
No need to-
They are not.
I'm not here.
They are virtually the same thing. So where do you wish to proceed now?
As I stated, my
Do
motion.
you wish this set for preliminary examination? Your motions have been
I
denied.
wish for the prosecution to provide the evidence that any of this needs.
You
to
don't have discovery on this case. Is that what you're asking?
I'm not asking for discovery whatsoever.
So what are you asking for?
I stated that the prosecution needs to prove that a crime was committed, and they also need to show and prove that there is an injured party for the crime to have even been committed.
As I've indicated, you will have that hearing.
A sustained, high-tension exchange about whether this proceeding is a probable cause hearing. The defendant insists. The judge clarifies the stages of criminal process and what a preliminary exam entails. This back and forth functions as both drama and legal education. The audience watching procedural mechanics unfold while the defendant repeatedly tests the boundaries of the court's protocols.
Do you wish to have discovery?
Discovery should be provided regardless. There's no wish about
Do
it.
you wish to have
Discovery
discovery?
should be provided.
Don't play word games with me.
I'm not playing.
Mr. Allen,
Discovery.
not play word games with me. You're playing with the wrong judge. You can smile and smirk all you want.
I'm not trying.
I'm giving you your warning. I will ask you again. Do you wish to have discovery provided to you?
Yes.
Do we have copies of discovery available that can be provided to this defendant?
No, Your Honor, I know that the PD was representing this individual. I don't have copies right now.
I got you. Okay. Mansour, are there copies of the police report as well as other discovery that's in the hands of the public defender's office?
I do see traffic stops and discovery videos onto our program.
All right.
Documents.
All right. Those need to be gotten to the defendant.
Yes, sir.
How soon can those be gotten to the defendant?
I can get those in hopefully by tomorrow around